All right, let's now take a closer look at some of the reasons being given for this particular petition by the petitioner, who's a Kenyan citizen from the county of Wajir. This petition is currently before the National Assembly. Let's take a look at some of the snippets of the prayers he has, so to speak, and why he thinks that Dr. Fred Matiang'i is violating the laws of the land. So he says that Dr. Matiang'i has jointly or severely with others committed acts of gross misconduct of his functions, and he definitely goes ahead to cite all the instances that he thinks that Dr. Matiang'i and others failed to uphold the laws of the land. He says that they failed to uphold his oath of office to defend the Constitution, and that he is incompetent to continue serving as a cabinet secretary. And of course, here in studio, I am with lawyer George Kithi. We will be going through this bits of that particular petition as we go. For starters, just someone coming up with a petition seeking to oust the Interior Cabinet Secretary. This is not the first petition, or almost a petition, we are seeing against a CS. We saw one against Cecily Kariuki that went down the drain just like that. But this, just a petition against him. What does this mean for him as a Cabinet Secretary?
Well, first and foremost, it ensues from the pronouncement by the court, the conviction that he was contemptuous to court, and eventually the punishment that was meted out to him of cash shillings 200,000 fine. Fast forward to that is that then the questions as to whether or not, having been found to have disobeyed an order of court and therefore suffer the sanctions that were given by court, whether he should continue to hold that office. It is from that background that then the petition has been put before Parliament, as procedurally anybody wishing to do so can do so. Well, it is a right of all citizens ensuing from Article 1 and the provision of the Constitution, especially Article 10, read together with Chapter 6, that then provides the environment upon which such a complaint or a petition can be brought forth to Parliament. I think it's a demonstration, again, of the oversight role by the people through the representative in Parliament. Parliament then, of course, has to interrogate this. The person who should be heard here is Dr. Matiang'i, because he has to convince himself that the allegations that are being made are not the correct allegation. And certainly, we do know he studiously do so, as we found him doing yesterday.
You speak about him defying court orders, and that's definitely one of the things that are being cited in this particular petition. The petitioner says that Dr. Fred Matiang'i and officers under his docket failed to officers under his command and direction brazenly refused to honor and obey the court's wise directive. And it was not one court order, it was not two, it was several court orders that Dr. Fred Matiang'i and officers under him went against.
The defense by Dr. Matiang'i, I think the best he has is that he was never served. And secondly, that's a follow-through that he could not execute the orders of court as was mandated. Now, those are conflicting positions, because if you can't execute court orders, you must then know that the court orders are there. There's this narrative that always people have, that unless you're served by court, with court orders, then you have no business following court orders. A command by court, the moment it comes into your knowledge, you are duty-bound to follow it, notwithstanding whether you've been served or not. That's the law. And therefore, the clarion call of most lawyers will hear them saying that notwithstanding service upon you, the fact that this is a notorious issue in the public debate, as we're doing it now, as has been done before, as has been followed through for days now, it's obvious that everybody worth his salt in leadership knows that he's bound by the pronouncement of the court. In any event, I think as a civil servant or any state officer for that matter, you are duty-bound to investigate matters security, including one that confronts you in the public domain as that. And therefore, the defense that you do not, you have not been served with court orders or any papers or petitions is not available for now. And in any event, the conviction has been made. So the only avenue, I think, is then to set aside the conviction through an appellate process or going back to the same court and pronounce himself as he pronounced himself in Parliament, as we had.
But even as the Interior Cabinet Secretary argues that he wasn't served, even on live TV, we saw how lawyers for Miguna, led by Senior Counsel Dr. John Haminwa and James Orengo, were trying to serve these court orders. They're trying to put them up on the walls at the airport where they were. They're trying to read them out to the officers. They said they had tried to email them. I mean, this argument that he wasn't served, can it hold water?
Like I said, first, if he wasn't served, that's a very weak defense in matters contempt, especially in a matter as notorious as this. Point is, service in itself is not an want of service in itself is not an excuse for disobeying a court order. The mere fact that that order came into knowledge, or his knowledge, sufficed, and therefore he had or was duty bound to obey it. But number one. Number two is the moment you say that you were in a situation that you could not obey the court orders, means you knew about those court orders. Knowledge itself is enough for one to be contemptuous of a court order. And thus the pronouncement of the court, notwithstanding the protestation that he was not served, he knew about the court orders.
So it doesn't hold water?
No, it doesn't hold water. It's not available for him now. I think the best thing available will be those orders that convicted him and pronounced a sentence against him, which he must fulfill, stand to be orders of court in eternity until they're set aside or appealed against in one way or the other. So if they're not going to be reviewed by whatever means, then the argument or the petition that he can't hold a public office has ground.
All right, let's take a look at something else from that particular petition, part of that particular petition against or seeking for the ouster of Interior Cabinet Secretary Fred Matiang'i, the petitioner saying that he is in gross violation of the Constitution. He says that in the same unwisdom of ignoring yet another time, Dr. Matiang'i deported Miguna to Dubai under regrettable conditions from Miguna. Of course, we've seen him deny this. They said he wasn't deported. He was just an undocumented passenger, or so to speak. But the argument of gross violation of the laws and ignoring court orders by this particular petitioner, do you think it is enough to have the Cabinet Secretary ousted from office?
Well, the truth of the matter is, nobody can be excused from the trappings and the duties bestowed on a public officer under the Constitution. Any abrogation of the same must attract the necessary sanctions, especially if the public moves to state as much. Therefore, Article 18 and Chapter 6 of the Constitution are beholden to any public officer. It is the first time this is coming to the fore. I know it's going to be debated. The only thing that probably will stand against or for the merit will be the numbers in Parliament. Obviously, we do know that he is a very important Cabinet Secretary to the current government. The current government has numbers in Parliament, and therefore probably that will be the misgivings as to proceeding with this motion or this petition before Parliament. But again, the discussion around it is the confines of the Constitution, the bounden duty of public office or state officers to follow the Constitution to the latter, and the relationship between executive and I'll call it a frictious relationship that has been there for some time between the executive and the judiciary vis-a-vis the oversight role played by Parliament. So the sum total of it is that it's again mirrors on the executive intent on putting bottlenecks to obedience of court orders, which then obviously has to be condemned through and through. Anyway, some orders are given by courts, they're appealed against and they're set aside. Some orders are given by court, and when a contestation comes as to both sides being heard, they're being removed. But the mere fact that orders are there, when you're stopped from doing something or commanded to do something by court, you must invariably obey it and struggle to go before court to present your side of the story.
Okay. The petition also says that on the 28th of March in 2018, following a series of flagrant disregard to valid court orders and directives, the Land Lord Justice George Odunga, just citing some of the orders that were given by Justice George Odunga and that have been disregarded so far. I want us to take a look at what Dr. Fred Matiang'i, the Interior Cabinet Secretary, said yesterday when he appeared before the National Assembly Committee on National Security with regard how the courts have been handling this case and the court orders that have been put forth on him and other officials of the government so far.
We have gotten into an unholy relationship with a clique of activist lawyers and oppositionist civil society people with the intention of humiliating the government, stalling the government, embarrassing the government, and making it impossible for the government to perform.
There are so many Kenyans.
All right, so Dr. Fred Matiang'i, there appearing yesterday before the National Assembly Committee on Security, saying that there are civil activists in court. He went as far as calling them evil over the court orders and the contempt of court and how he was fined there by Justice George Odunga, with a very senior government official speaking like this about one arm of the government, one serious arm of the government. Is this recipe for a complete breakdown of the relationship between the executive, the legislation, and the judiciary?
No. I don't think so. You see, why are we having laws? We don't even need laws in the first place if people behave themselves. But we have laws in the manner we have in the Constitution because we anticipate excesses by the executive. Now, some of these excesses are not discharged in bad faith. Some of these public officers do their duties in all due diligence and within the confines of good faith. But they do so without knowing that they're applying logic and not applying the law. The problem is with the law, you can look at it at the side that you want and interpret it. Every time a cabinet secretary, for instance, discharges responsibilities, he discharges a constitutional function and therefore continues to interpret the Constitution every time. A duty that is imposed by the Constitution to interpret it to the favor of the citizen. Now, in the context of a powerful person working in government with all trappings of power and a citizen that then is looking up to protection by that person, the interpretation should be in favor of the person, whether Miguna or anyone else. If then you overstep your mandate, you'll be checked by the same Constitution, and therefore the availability of the courts. The courts, as designed by the Constitution, will always be an irritant to power. Irritant because they stand in between power as against the people of Kenya and those that are ruling. It's basically, as we've put it invariably, a contract between those that are ruled and those that are ruling. Those that are ruling are in the executive and other arms of government. Now, what happens is they discharge their responsibilities against the people of Kenya or for the people of Kenya. When it's against, the people of Kenya must rush to court, and the court then the court disturbs the status as has been discharged in that function. When they do so, the person seeks, who has done so, as Matiang'i has rightly said, becomes irritated. And then he sees as if he can't move because his hands are tied. But they're tied within the function of the Constitution. Until the day we change our Constitution and allow liberties as wide as possible to people in power, they'll continue to be irritated by court orders. And therefore, we must commend the courts to stand with the people where it matters. But at times, it doesn't do that because the circumstances bind them as much. But for the time being, I think courts should continue to irritate the executive because that's where then justice is.
But then do you think a precedence has been set, especially on government officials, as far as obeying court orders is concerned? Are you worried that a precedence has been set?
I think the courts, to that extent, are to blame. There are times when the courts are faced with situations where they're being ridiculed by either executive or persons in the executive or any other places. And they don't, when complaints are brought before them in contempt, in contemptuous matters, they look behind their back. So judges of today should learn, as has been demonstrated, that they have to be as brazen enough because they're not discharging those that mandate for themselves. They do so for the people of Kenya. And this should continue until a day when the fear in a public servant is such that then I should do the right thing, because if I do the wrong thing, the oversight role of the people will be taken to Parliament, to the judiciary, and I'll be stopped. So the path to chart out the constitutionalism is not easy. It's going to be frictious. It's going to bring about the differences we see between the arms of government.
Yeah.
But it must continue invariably until such a day when you have men and women in public offices who then know where they start and where they stop.
All right. Thank you very much for coming in. Always a pleasure to have you here on KTN News Desk. George Kive is an advocate just helping us understand that petition that is currently before the National Assembly seeking for the ouster or removal of office of Dr. Fred Matiang'i, the Cabinet Secretary for Interior, over gross violation of the Constitution and, of course, not obeying or constantly not